Good morning. So, I wake up this morning on the eve of the NCTJ Media Law Court Reporting and Associated Matters exam. My revision isn't quite up to scratch, but we'll try with this video to get the thoughts on this. My revision notes into my brain. Will that work? I don't know. Seemed to work last time. So let's have a look. Warning: if anyone else is watching this, I take no responsibility for you passing or failing. These are my notes, so for my benefit only. So, the NCTJ put on a programme of study, which is quite handy because it tells you exactly what will be in the test and where the page references are in McNae's and what you need to know but won't be tested. So what we've done is gone through each part of that guide. There's 10 parts of it, and try to pick out key bits from McNae's to remember. So this is what we'll be reading through. So we'll start with part 1, which is basic knowledge of the law, of court processes, and of the hierarchy of the courts. So, starts off, you need to know that sources of UK law include common law, precedent, case law, statute. So remember that. But in many instances, courts have to consider the European Convention on Human Rights when making decisions. So think ECHR, Article 6, right to a fair trial, 8, privacy, and 10, freedom of expression. And the Human Rights Act of 1998, which came into force on the 2nd of October 2000, which put the convention into UK law. You've got case law to remember, RES, HR 2004, UK House of Lords, where Lord Stein weighed the competing rights between Articles 8 and 10. Basically, the conclusions were neither article has precedence over the other. If two conflict, focus on the comparative importance is necessary. Justifications for interfering with or restricting each right must be taken into account. And finally, the proportionality test must be applied to each, which Lord Stein called the ultimate balancing test. You also need to know the divisions between civil and criminal law and examples of an event which could give rise to both criminal and civil proceedings. Touched on in the previous exam, McNae's provides an example of a motorist in a road accident where he can be prosecuted for dangerous driving, which is a criminal offence, and sued by someone injured in a crash for damages, which is a civil case. We've then got correct use of the following terminology. I haven't done the definitions yet, so that might come later, but the terminology quoted is charge, prosecute, claimant, defendant, as appropriate in relation to civil or criminal courts, solicitor, barrister, counsel, to sue, damages, claim for, tort, injunction, settlement, found liable, that is held liable, and omitted liability. On to the next page. That the main courts, civil courts, are the county courts and high court. It might be worth knowing that the high court is split into 3 divisions here. You've got the Queen's Bench division, which includes special courts of admiralty and commercial. You've got the Chancery division, which deals primarily with companies, trusts and insolvency. And we've got the Family division, which has private matters like matrimonial and public like adoption sections. Example of the types of case heard before civil courts, including county courts, e.g. debt recovery, other breaches of contract, and other torts such as trespass, negligence, copyright infringement, and in the High Court defamation, bankruptcy, divorce, and care proceedings. So nothing to add on that one. Also need to know that it is rare for juries to be used in civil cases, even in defamation cases, and that the types of civil case in which they are most likely to be used are claims of fraud, malicious prosecution, or false imprisonment. 1.1. That criminal proceedings start because of an arrest, or charge, or summons, or written charge, and requisition, or arrest warrant. The extent of information set out in the charge, that it normally contains basic details of the allegation, including the name of any alleged victim, and of any property allegedly involved, e.g. in a theft case, for example, a description of and monetary value for the property allegedly stolen, and the owner's name. You need to know what police bail is. This is where officers want more time to complete investigations. The definitions, and this is something again, more definitions which we'll come back to possibly. Theft, taking a vehicle without the owner's authority or consent, handling, burglary, aggravated burglary, robbery, blackmail, fraud, perjury, murder, and manslaughter. Now, on top of this, you also need to know whether these offences are indictable only or either way. And you also should see subpart 2.1 of this programme about that, and that the offence of driving with excess alcohol may not mean the defendant was drunk. On to 1.3. What court bail is and typical bail conditions and when it can be refused. So bail is when a court grants liberty until the next court hearing. The Bail Act 1976 says the defendant must be granted bail, and we'll flip to page 56 in McMays. Must be granted bail unless the court is satisfied there are substantial grounds for believing that if bail is granted, the defendant will abscond, or he/she will commit another offence, or he/she will obstruct the course of justice, for example by interfering with a witness, or he/she will or will be likely to cause mental or physical injury to an associated person or cause him to fear such injury. It continues. The court decides that the defendant should be kept in prison for his/her own protection. For instance, if the alleged crime has so angered the local community that a mob may attack him or her. The defendant is alleged to have committed an indictable offence when he/she was on bail granted in an earlier case. The defendant is already serving a jail sentence. There is insufficient information to decide on bail. A court must give reasons for refusing bail. A defendant charged with murder can only be given bail by a Crown Court judge. You also need to know who a surety is, a friend, relative of the defendant who guarantees that the defendant will surrender to bail. Surety agrees to forfeit a sum of money fixed by the court if the defendant absconds. That an appeal against refusal of bail by magistrates is made to a Crown Court judge, where the appeal hearing may be held in private or in chambers. When a hearing, usually a preliminary one, is held in judges' chambers rather than a formal courtroom. 1.4. Procedure in, that is, the stages of summary trials in magistrates' courts, and that the procedure for trial at youth court is similar. So again, we'll go to McMays, page 60, this one. Another long bit. So the usual summary trial procedure is as follows. The prosecutor makes an opening speech describing the alleged crime. Witnesses testify after swearing an oath or affirming that their evidence is true. Prosecution witnesses are called first. Each is asked questions by the prosecutor to elicit their evidence in chief. That is evidence given during questioning by the side which called them. The defence can cross-examine them. The prosecution may then re-examine them. When prosecution evidence ends, the defence may submit for any or all charges faced that there is no case to answer. That is, that the prosecution cannot meet the standard of proof required. If the magistrates agree with the submission, they dismiss the charge. Otherwise, or if there is no such submission, the trial continues. Defence witnesses are called. These may include the defendant, though he/she cannot be compelled to testify. Defence witnesses are questioned to elicit their evidence in chief. They can be cross-examined by the prosecutor and then re-examined by the defence. When the court has heard all witnesses, the defence may address the court in a closing speech, arguing how facts and law should be interpreted. Either side can address the court twice in total in opening or closing speeches. The defence has the right to make the last speech. If the magistrates feel a charge is not proved, they acquit the defendant. If they find him/her guilty or on any charge, he/she is convicted of it, and the magistrate sentence the defender or adjourn to sentence at a later date. Let's pause a minute.